This Honorable Court of Appeals of Tennessee is now in session.
Thank you, Mr. Clerk. To the attorney that is present, we welcome you to the Tennessee Court of Appeals. Apparently there is a little, I wouldn't call it a mix-up, but there is a little oddity. The thing is, we will proceed with this case. You would have your time to make your argument, and we will take this case to the panel. The panel will decide this case eventually, unless somewhere down the road, and I would advise you, if you're going to do this, the parties, that you do it swiftly, put down an agreed order, remand or dismissal, okay?
Okay. Mr. McClarty, I apologize. It appears that Mr. Looper is now joining us. So
We'll bring him in.
yes, sir. Nick, if you can bring Mr. Looper in with us. Mr. Looper, can you hear us? You're on mute right now. Could you unmute? There you go.
Yes, I can hear.
Mr. Looper, are you prepared to proceed in this case, or is there any announcements need to be made to the court?
Well, I think we could make an announcement. I think if Miss Oldfield is still in agreement, we had agreed to that you, this honorable court, will remand the case back to Chancery Court for a trial de novo, if that's still her position.
Yeah, I do not oppose that at all. I think that we've discussed that matter, and I was not the attorney of record at that time. So after having examined Mr. Looper's argument and speaking with him, I do think it is appropriate to be remanded back to the Chancery Court for a full hearing.
Okay, not the juvenile court?
Well, I would have a question about that. I mean, juvenile court has not really decided the issue on the merits with all parties being present. So I don't know why I would go to the trial court to make that decision. It would seem to me it would have to go back to juvenile court.
I would
say about that, Mr. Looper.
Sir, I think I would defer to your judgment on that. I do think it would have to be a full trial, though, as you said, on the merits.
Yeah, but circuit would then review the decision on the merits as an appellate court, but de novo. But they don't have anything to review now, because when it was heard below in juvenile court, there was a party that was not present because they didn't get service or notice. Is that right? Am I understanding that correctly?
The juvenile court had determined that they did have proper notice, but then that, I imagine that part was appealed to the circuit court, which in Anderson County, I think the Chancery Court sits as the circuit court for domestic cases coming out of juvenile. So, and then at that point, the chancellor had made the decision that they did not have proper notice and remanded it under Rule 60 back to juvenile court. It was my position that Rule 60 would be a rule that for clerical errors, mistakes, omissions, and excusable neglect on orders of that particular court. I did not think it applied to a court below. If that argument makes any sense, Your Honor.
Well, there's a statutory Rule 60 for general sessions, but the problem in this case, if you don't have service, the decision below is simply invalid. And as I understand it, that's the argument, that there was no service. And so you can bring that at any time. You aren't bound by that 10-day limitation.
That argument was made in juvenile court. The juvenile court ruled that there was proper service, and then that decision was appealed. Does that make sense, Your Honor?
Yeah, it was appealed, And then the trial court made the determination that there was no service.
Correct.
And the trial court says it needs to go back to juvenile court for hearing on the merits as to whether or not there should have been reunification. And then once that decision is made with all parties being present, that could then be appealed to circuit. And then the circuit judge would make a determination about the decision on the merits, because right now, all the circuit court did was made a decision about the Rule 60 motion, about service, not about the merits of the case.
Okay.
As I understand it. But that's my view. I mean, somebody else may have a different view of it. I don't know.
I concur. I think if it's going to be a remand, I think it has to go back to the juvenile court. Okay. Y'all want to consent to that, if that's what you want to do?
Your Honor,
is to make a decision.
I mean, I agree with that decision. That was the decision of the Chancery Court. They remanded it back to the juvenile court. So that was obviously what the desire was of my clients at the time, that they filed that. I'm not really sure why we ended up back here and ended up with the exact same, basically the exact same thing that was asked for in the beginning. So I don't have a problem with it going back to juvenile court. That's what it was initially supposed to do, was to be remanded for a full hearing at the juvenile court.
Okay. And if that is the case, if you want to put down an agreed order, you can do so. Or if you want us to take the matter to the panel, we can make that decision.
I'm fine with an agreed order if that's okay with Mr. Looper. I think that might be more efficient.
That would be fine with me, to the extent that we would agree to try the case again in juvenile court. My clients had these children for almost a year now. As long as we didn't lose custody of the children, I think I'm good with that. Otherwise, I would argue that the Ray Jaden A case probably would control, but otherwise, where we try the case itself basically I don't have a problem with it.
Okay. If the party submit an agreed order to the court, we would honor the order and remand this case back to the juvenile court for a trial on the merits, resolution of these issues. Okay. Okay. Anything else we need to consider on this matter?
Don't believe so.
I'm fine, Your Honor. That sounds good.
Now, I'm saying if the party submitted an agreed order, I'm ordering that this agreed order be submitted no later than 5 days from today. That is an order that I'm putting down directly to the parties, okay? Okay,
Thank you, Your Honors.
Thank
okay
you.
then.
This honorable court is now in recess until 2:30 p.m.
The parties may be excused.
Thank you.
Thank you, Your Honor.